Hi, my name is Hannah Hill. I'm the Research and Policy Director for the National Foundation for Gun Rights, and I wanted to bring you an update on our Supreme Court appeal for emergency relief from Illinois' semi-auto ban and the city of Naperville, Illinois' ban on the sale of AR-15s. So we recently appealed this case to the Supreme Court because the District Court and the Seventh Circuit both refused to block these laws and bring relief to the citizens of Naperville and to Illinois. So what we are asking the Supreme Court to do is to step in and give us an injunction pending appeal. So to prove that, we have to prove three things. We have to prove we're likely to prevail on the merits, that we'll suffer an irreparable harm absent the injunction, and that injunction will not harm public interest. So we made all of those points, and Justice Amy Coney Barrett, who receives emergency appeals from the Seventh Circuit, she reviewed what we said, and then she turned to Naperville and to Illinois and said, now explain to me why I should not grant this, essentially. That she asked for a response from them. Their response was due this morning. So I just wanted to take a couple of minutes to go through the arguments they're making and explain why they don't hold water. But real quick first, if you haven't already, please take a minute to like this video and subscribe to our channel. There's a lot happening with this case and with other Second Amendment litigation that we're involved in, so that will make sure that you don't miss the latest news and updates as they are available. All right, so here's what they are saying. Now, Illinois and Naperville each filed a brief in this case. They're essentially making the same arguments. I'm pretty much going to be focusing on what Illinois said because it's a bit longer and a bit more comprehensive here. So in the first place, they're claiming that we supposedly have not proven that semi-automatic weapons are in common use for self-defense. The only thing I can say to that is bless your heart, because we have. And to argue that the most popular firearm in America is not in common use is downright laughable. Now, they're saying, to back that statement up, that our sources that we're using to point to the fact that they are in common use are, quote, unreliable and otherwise flawed. And they say that, and they're claiming that we're pointing primarily to online studies and to news articles, which that's a red letter day right there, because the left is now claiming that the mainstream media is unreliable and otherwise flawed. But I want to point out those are not the only sources we used. We quoted directly from the ATF, and I'm quoting from our brief here. In 2022, the Bureau of Alcohol, Tobacco, Firearms, and Explosives acknowledged that the AR-15 type rifle is, quote, one of the most popular firearms in the United States, including for civilian use. So they're going to have to take it up with the ATF if they don't think this weapon's in common use. Second, they're also claiming that standard capacity magazines, or large capacity magazines as they're trying to cast them as, they're trying to claim that they are essentially cartridge boxes, that they're not actually arms protected by the Second Amendment. And that's simply hogwash as well, because a magazine doesn't simply hold ammunition. A magazine is an essential part of the mechanism of a semi-automatic weapon. It's a part of the gun, so it is protected. Number three, they're twisting the standard of in common use, commonly owned for self-defense. They're twisting that to say we have to prove that the weapon is frequently, commonly actually used in self-defense situations. And that's not what the test is at all. That's not what the Supreme Court has said. The only reason they're trying to shift that ground is because they know they can't win on the Supreme Court's simple test in Heller. Number four, they're saying, now history says that we can actually ban these weapons. And to explain that, you'll recall that the Supreme Court said in Bruin last year that if a government wants to regulate or ban guns, they have to prove that their law is consistent with the text, the history, and the tradition of the Second Amendment. And this is their attempt to do that. They're saying that history allows it, but even though there are no historical parallels for this type of law, nobody in the founding era or the era immediately following it, no state ever tried to outright ban commonly owned weapons, commonly owned for self-defense purposes. So what they're saying here is that we have to be nuanced when we approach it. And so they just basically nuanced the test right into oblivion. Then they bring out the fact that these weapons are supposedly so very dangerous and say that these changes matter because we have new technology, we have new problems created by these guns. And what they're essentially doing there is a backdoor cost-benefit analysis. They're saying that you have to weigh the constitutional right against the supposed cost of that constitutional right and see which one comes out on top. That's exactly what the Supreme Court said you cannot do in Bruin. They said you have to look at the text and then look at the surrounding history and context to see what that right meant to the ones who enacted it. And they said, and by the way, make sure you don't use the historical test as a backdoor way to get back to that cost-benefit analysis, which unfortunately is exactly what they've done. Now, I wanted to also review what we told the Supreme Court. After all of that nonsense, this is what the Supreme Court needs to be focused on. Here's how we opened our brief. This is an exceedingly simple case. The Second Amendment protects arms that are commonly possessed by law-abiding citizens for lawful purposes, especially self-defense in the home. The arms banned by respondents, Naperville and Illinois, are possessed by millions of law-abiding citizens for lawful purposes, including self-defense in the home. Under this court's precedent, that is all that is needed for citizens to have a right under the Second Amendment to keep such weapons. There cannot be the slightest question, therefore, that the challenged laws are unconstitutional. Full stop. This is not a complicated case. The only reason they're making it complicated is because if they rely on the actual test and the actual facts, they know their case loses every time. Now, finally, they're saying that, okay, yes, in the First Amendment cases, the courts have ruled that basically trampling on a First Amendment right for any length of time creates an irreparable injury. They say, but that doesn't apply to the Second Amendment. Although the court said in Bruin that they repeatedly pointed out that they wanted the two rights to be treated exactly the same. For instance, in Bruin, they said, this Second Amendment standard accords with how we protect other constitutional rights. Take, for instance, the freedom of speech in the First Amendment, to which Heller repeatedly compared the right to keep and bear arms. So they're deliberately comparing the way they're treating the First Amendment with the way they're treating the Second Amendment and saying this is the way that we want it to be. And then in conclusion, it doesn't get much more plain than this. This is how Bruin ends. The constitutional right to bear arms in public for self-defense is not a second-class right, subject to an entirely different body of rules than the other Bill of Rights guarantees. We know of no other constitutional right that an individual may exercise only after demonstrating to government officers some special need. That is not how the First Amendment works when it comes to unpopular speech or the free exercise of religion. It is not how the Sixth Amendment works when it comes to a defendant's right to confront the witnesses against him. And it is not how the Second Amendment works when it comes to public carry for self-defense. So it can't be more plain than that. The court in Bruin put the Second Amendment on the exact same footing as the First Amendment, which is exactly how the founders intended it to be. That's the point we're making, that a right delayed is a right denied, that Illinois and the city of Naperville are trampling on the right to keep and bear arms as protected in our Constitution, and we're simply asking the Supreme Court to step in and put a stop to it. So we will keep you posted on developments. Again, please make sure to like this video and subscribe to our channel to stay tuned, and we will keep you posted on what the Supreme Court says.